All right. Well, we have a very special guest on our podcast today. Got our friends Josh with Orange Coast Title Company. We're here in Southern California, but they insure across the country. Josh, you want to give a brief introduction?
Hi, yes. So my name is Josh Hernandez. I'm an attorney with Orange Coast Title Company. I have been practicing law since 2008. I've been focusing mainly in real estate throughout my practice. I did the law firm lifestyle for about over 10 years, working for a smaller firm kind of in this area. Actually, we were defending lenders, loan servicers, foreclosure trustees in foreclosure litigation on the lender side. I got good experience. I enjoyed where I was, but I wanted to kind of get an experience about having the in-house corporate counsel lifestyle versus the law firm lifestyle of billable hours, churning out hours, and things like that. So just around towards the end of 2019, I decided that I wanted to figure out what was next for me. So I was looking around, and then Orange Coast Title Company just had a position open for an in-house attorney for their legal department. And after a few interviews later, I was really comfortable with the company, the people involved, and they decided to bring me on, and it's been almost 4 years. This was just before COVID too, so I ended up having to be involved not only in corporate title issues, but the COVID policies and things like that, and making sure we were all following that. So it's my responsibilities are as a corporate attorney, the in-house legal department. It's not just the title stuff that we do. It's actually, I have to look at potential HR issues and compliance and things like that. But certainly most of my time is involved in title and title insurance claims, which is always very interesting, and it's very, very involved, and you see something different every day. It's really exciting.
Well, Josh, you've been through two catastrophic events. You went through the Great Recession.
I did.
And if you were practicing real estate law at that time,
I did.
You saw a massive wave of foreclosures, and the industry was kind of upended. And then like a few years later, went through COVID, and that was a whole other crisis. So
yeah, it was interesting. So that's what brought me. I think that's what brought me to my old firm, which was around 2010, which was the defaults and the foreclosures were really kicking up. And so these borrowers were filing lawsuits to stop their foreclosure, or they were declaring bankruptcy. And our firm was representing the lenders at the time. So, they're trying to proceed with the foreclosures because no one's paying the bills. And so the need for foreclosure attorneys was really, really big back then. And it kind of I rode the wave for a while. Then, cut to COVID. Ended up being the biggest year in real estate for a lot of title companies. And so it just was really, really big. Then we saw what happened a year or so after that. It kind of took a big dive because the interest rates blew up, and so the transactions weren't happening as much. But certainly around COVID, around that year, was a really big, heavy real estate market.
That was a really interesting phenomenon during COVID. People were quarantined, isolated, wearing masks when they went out, and yet property sales surged. I was curious what the reason was for that.
Yeah, it's hard to say. They took advantage of the low rates at the time. They were cooped up, so maybe they were just thinking, no, I'm looking around, but I don't want this house anymore. I'm quarantining here. Maybe we need a bigger space, or they figure maybe they want a bigger family, so they need another room, or just a lot of different motivations that really kicked up the market, and housing prices went up and all that. So that was really helpful to see, as far as someone who's in the title industry, that you see an increase in sales.
Suddenly people are stuck at home, and they're realizing, I don't like my home. It's too small. I've been here too long. The other thing, contractors actually remodeling homes.
Sure.
They were busy. They were super, super busy. People trying to rebuild and remodel, stuck Definitely. At home. So either remodel or move.
Yeah, exactly. So, and we were there to help them with whatever we needed to do.
So I imagine you see trusts involved with a lot of the escrows that Orange County Title and Escrow works with.
Right.
Do you see situations where trusts are easy to get title insurance for, or where they sometimes pose difficulties?
Yeah, so we see transactions involving trusts a lot. it's when people have their various motivations for putting their properties into a trust to begin with, as you know, it's the difficulty in getting a title insurance policy if you're trying to sell as a trust it's not as difficult as one might think. It's just there's different considerations that we have to take into account. If you're a title company, your job is to really sort of mitigate risk is what you're trying to do, because it's insurance. So what are the risks involved in insuring a transaction involving a trust? Well, it's going to be, what does the trust document say? Who's the trustees? Who are the beneficiaries? Is the trustor settlor alive or dead? What do the terms say? Who's in charge? Do we have objections? Are people not really enjoying, or they don't agree with what the transactions are going to be doing? They don't want to sell the house, things like that. So we have to look at that risk, see if there's anybody out there that may or may not object to it. But usually as long as you have the trust document for us to review, we make sure that the sequence of events is right, where the person who's the trustee trying to sell the property actually does have the authority to do it. And we don't get any word of any heirs or beneficiaries who are saying, I'm being cut out, or I don't approve of this. As long as we mitigate that sort of risk, it's really not going to be an issue. We insure many transactions where there's a seller that's a trust entity. Definitely.
Yeah. Mm-hmm. That's good to know.
Yeah, and Josh, have we seen any, maybe just step back a little bit, have we seen any lawsuits happen around this? Because the trust, we have this document, and the trust, who cares if a kid's getting cut out? That's the trustee, or, let's say dad's trust.
Yeah.
So what happens from a title insurance perspective on your guys' end to ensure that?
Yeah, so when the point about litigation and trust is it does happen, certainly. You'll see it where someone who is a beneficiary, or someone who thinks that they have the right to be the trustee but not, they'll sue to overturn whatever amendment there was, or they'll say there was undue influence in someone amending the trust document to where it is, no, this amendment is invalid because of this, it should be this, so I want that kicked out. You'll need a court order for all that stuff to settle it. So if we see that, then we'll take a look at it, and we'll let the litigation play out and see what the court says about it. The thing about trust and litigation that is, I think, beneficial to really help people is in avoiding probate is, as you know, the benefit of having a trust and your property within a trust is that when the person dies, you don't have to go through probate necessarily.
Saves time and money. It's more expedient. So, you don't have to go through a probate process if you die and your property's in the name of the trust as the trustee. If you die, the ownership just goes to the successor trustee, and then the successor trustee has the fiduciary duty to implement the trust terms for the benefit of the beneficiary. So I think that's certainly the calm and comfort that people have in putting their properties into a trust. Not everyone, it doesn't work for everybody, as I'm sure you counsel your clients about that. Sometimes it doesn't work out for them. It's not the best idea, but a lot of times it is. There's a little wrinkle, though, as far as sometimes when people intend to put property into a trust and it doesn't happen. Didn't quite record the grant deed.
Didn't get there. So there's a thing called a Hales petition, which I'm sure you probably heard of, under Probate Code 850, and that's something we look at too. Is sometimes it'll come to us and say, "Hey, we got a Hales order. Will you take a look at it and ensure the transaction?" So basically, just the explanation is, the transfer into the trust didn't happen successfully, or there was an issue to it. So the trust attorney is going to file a petition in probate court to get a court order confirming that the trust asset is a trust asset. And so once you get that court order that confirms that the property is the asset of the trust, then that kind of shortcuts the full probate process. It's in probate court, but you don't have to do the whole probate.
Much shorter than a full statutory probate.
Much shorter. But yeah, so if someone dies with no trust and they just have the property within themselves, even if they have a will, that means they died testate. If they don't have a will, they died intestate. that's going to need a probate process to fully administer the estate. Now you can sell property before the full probate is completed. You'll just sometimes need court approval to do that. File a petition for court approval to sell the real estate, but that still takes a little bit of time. So the trust's route is certainly a very more expedient way to go for a lot of people.
What I've been saying in our practice is that the home is a bone of contention. Mm-hmm. It's a coveted asset, especially here in Southern California. It comprises the biggest source of wealth for any given family in most cases. Mm-hmm. And there's a lot of competition between siblings over who gets the house. Ooh, yeah. So typically mom and dad, we see this a lot, and I'm sure you have too, they create a trust and they leave it equally to all 4 children. And everything's good while mom and dad are alive. Then one spouse dies, and title remains in the trust, and now it's there for the surviving spouse to live in. But then the survivor starts to get old, maybe they get a little dementia, and then the youngest child moves back home to take care of mom or dad. And then mom or dad kind of wants to keep them there, and they say, stay here. Maybe one day this house will be yours.
Yep.
And they start making promises. Or maybe even the youngest child or whichever child has moved home now, taking care of mom and dad, they drive mom and dad or mom or dad down to an attorney, to a notary. They have them sign a deed, taking the house out of the trust, putting it into their own name. And that's where you get into the litigation. And in my experience, it's happening with a trust or without a trust. Whether there's a trust or not, there's still a good chance, especially with the super high real estate prices. Your average person can't even buy a home by themselves. So if they can snag mom or dad's home, screw the siblings. I mean, they're willing, many of these families, unfortunately, it's so desperate, they're willing to sever the relationship with all the siblings if they can get a hold of that house. But then they go to sell it, and that's where the litigation starts. And then another one of the siblings that should have got an equal share comes to you or me. They sue. We end up putting a lis pendens on the title. So when you're going to close escrow, you can't close because there's this lis pendens. And then all the lawyers have to work out a settlement, usually in court. And you can even be in escrow when this is happening. I'm sure you've seen that. You're in escrow, you can't close because the argument about who really should get the house, with or without a trust, hasn't been settled. And you can't close until the lis pendens is removed, right?
Exactly. Well, you covered a few things that just really ring in my mind because it's just I handle the claims for our company, and so it's this is just like
you got PTSD on this.
We handle it. We handle it the way we can handle it, but it's a lot of those fact patterns. Absolutely, the most contentious issues, unfortunately, that I see are between family members, siblings. Right. They just don't get along. They want their piece of the pie. And you'll see a family member, sibling, or uncle, whoever, take advantage of the property owner. Like you said, dementia. It's a thing. It's where the owner lacks capacity to enter into this contract to transfer the deed. So then the other parties are challenged that say, hey, our mom had Alzheimer's at the time when you had her sign this deed. That's ineffective. Right. So then, which is true, a document signed by someone without capacity, it's invalid. But
the problem is you have to prove that to the other side or in court. It's not easy to unravel.
It's difficult to unravel. You definitely need a court order to do it. You'll need the court to weigh in on and weigh on the facts, and you'll have to get. We rely on doctor's notes and things like that. Right. Okay, we'll have to measure the time frame. When was this person diagnosed? How long were they been treated? So that's a way we mitigate the risk. Okay, when was this person? When did they have Alzheimer's? When didn't they? And so it's sort of a issue that we have to play with too. But once you get past that point, then there's litigation, and then there's a lis pendens, which we have to resolve too. It's a lis pendens is a notice of a pending lawsuit, and that can be resolved. You can withdraw it, or you can get it expunged, or the case can be dismissed and then it's nullified. So there's things that we need to take care of too. But we if there's a lis pendens involved in a property, and we're aware of it, we definitely put the brakes on it and say this is something we need to take a look at, because The point of a lis pendens is the recording of the notice of action shows that the outcome of the pending litigation takes priority over anything that's subsequently recorded after it. So the title company certainly does not want to insure a transaction after the lis pendens, because let's say 2 years down the line, the trial happens in the litigation, then the outcome of that litigation takes priority, and then the title fails, and then we have a full claim on our hands. So yeah, those issues of trusts and contentiousness and court issues and lis pendens are something that we really definitely have to take a look at in issuing title policies.
And Josh, what would you say for, what is the importance of title insurance? We know it's involved in the real estate transactions, but, maybe for some people out there, it's like, I kind of forget like what I had, it's been so long ago I bought my house. And so, what kind of is title insurance, and like, why is it important, not only during the sale, even after?
Yeah, no, definitely. And I understand people, insurance, I don't need insurance, this is not going to happen. And I'm not sitting here trying to sell policies either, but there's a really important factor in getting a title insurance policy, that if there's something that happens to your title, I mean, it's just kind of self-explanatory, but and it's a covered matter, the insurance company is going to pay for your loss. And there's many ways you can have a loss. I think the most devastating ones that we see is fraud-related claims. So let's say that you buy a house, you think that, and so your seller has a mortgage on record, and through your purchase, the seller's mortgage gets paid off. So like you take out a loan to buy your house, your lender is going to pay off your seller's mortgage.
You're assuming they're going to.
Yeah, exactly, right. That's the whole point. And you see the settlement statement like, this is exactly how it's going to go, because you don't want to buy it with your seller's lien on title. You don't want that, right? So you assume it happens and everything gets paid off, and then a year later you get a notice of default posted on your property, and you're like, well, wait a second, I thought that this got paid off. And so you find out, the escrow company's computer was hacked, or their broker's computer was hacked, so they pump out a fake payoff statement to where your lender issues the payoff funds for the senior mortgage. They issue it to a fake account that was set up by a criminal, and so the criminal takes away the money, and then the senior lien isn't paid off, and so you're stuck.
Wow.
So that's where title insurance comes into play, because title insurance generally will cover fraud, and so your title insurance company is going to step in and say, hey, we're not going to let you get foreclosed on for something that's not your fault, so we're going to do something. Litigation might be an answer, where you file lawsuits, maybe enjoin the foreclosure sale with an injunction. Sometimes it's just a full payoff where, okay, look, we tender your policy limits. We're sorry this happened. Here's the money for your policy limit. So that's a big thing that'll help you if you have a title insurance policy. But it's even smaller things. Smaller things can be boundary disputes.
Yeah, I hear that one a lot.
We'll get your policy typically doesn't cover if your neighbor encroaches onto you. That's your neighbor's issue for trespassing. But if your property that we insured ends up encroaching onto your neighbor's property, then that's something that's generally going to be covered. We'll have to take a look at it. Usually we'll have to get surveyors involved, so we'll get a survey to map out what the lot lines are. Sometimes it's done with lesser of a survey, it's more of an inspection, but there's a mapping that's going to happen. And then, we'll have to figure out what the coverage is, what the loss is. We'll pay for the diminution of value sometimes. If it's small enough of an encroachment, sometimes we'll just pay to knock it down, which isn't a lot. If it's something where the lot is we insured your lot to where it's actually not a legal lot to begin with, sometimes we'll have to get more intensified and then get a lot line adjustment approved with the county. So you'll get a surveyor to file an application with the county to remap the lots between you and your neighbor to where your deed actually becomes part of that lot versus the one you bought wasn't correct. So we get a lot line adjustment with the county to make the one that you bought correct. So that's a process, but that's not at your cost.
That's good protection to have.
It's great protection to have because you never know. You never know. Or someone just making a claim, or you get sued by a crazy family member in these situations we were talking about. So you buy the house. You're not a member of the family. You buy a house, but then Junior comes in and says, "Hey, Mom promised me the house. I'm going to sue to quiet title. And I'm going to sue everybody, it's including you. Like what I didn't." I wasn't involved with this family, but I'm being sued over it, right? Oh. So your insurance company is probably going to cover the attorney's fees to make a payment to retain an attorney to defend you. Another one is another thing that happens is you're insured 100% interest, but then it turns out that somewhere along the line an interest was missed, so you find out you don't really own all the property.
12.5% was several steps back was somewhere else.
Happens. So it's true. There's actually one that I'm thinking about. I only own 12.5% of the property. I thought I bought the whole thing. So that's where you tender that to your insurance, and then your insurance is gonna cover the fees, which is probably going to require quiet title action, and then still cover the fees to institute that, and it's going to have to sue everybody before you to quiet their title, and then it gets a court order that finally vests title into you. But that would be out of your pocket without a title insurance policy. So there's just a number of covered matters that are really helpful to have a title insurance policy with you.
I got a couple questions. So typically, does a title insurance policy run the length of the ownership? Or does it expire after a certain number of years? Or does it run as long as you own the property?
Again, this is just a contentious issue that we have to deal with sometimes.
Your average policy.
Yeah, no. Yeah, So there's generally speaking, your insurance policy ends at the time you transfer it. So if you sell the property, you're no longer an insured of your insurance company. The title is now insured by another title company, or if it's the same title company, it's under a different policy. Right. There's some versions of the standard Alta form, like particularly 2013, which are written as such that it's arguable that it still survives after your transfer. I don't know why Alta wrote it that way, but they did. There's language in there that suggests that it insures you, quote unquote, forever. So if you're sued down the line for something you did with your policy or something you did with your ownership of the property, there's language in there that says it actually survives the transfer. So it just depends on what your policy says. That's
interesting. That Alta clause opens the door for the new company that insured the later transfer when you transferred it to reach back and sue the old insurance company because theoretically now they're still on the line, right?
Yeah.
That's a little messy.
Yeah, it's or we just have to work together, or they accept the claim from the new owner and then we have to accept the claim from the old owner, and then we work together to get a resolution. But it's messy and but again, if your policy says so, we'll have to cover it.
Well, then you might end up with double coverage: the new insurer, the old insurer, and like you said, you work out a settlement.
You work it out. There's some issues where we're working with other title companies who have the title now, but there's that clause in there that says insures you forever. But generally speaking, I don't want to overstate it. Generally speaking, your policy does end, depending on what this clause says, but depending on which policy you have, it does end by the time you transfer it.
So what if you die before you transfer it, and then your successor trustee of the trust sells it later? I'm guessing the policy coverage would extend through until, as you said, the title is transferred, even though you're not transferring because you're not alive, but until the property is transferred.
Well, yeah. So the legal entity that a trust creates, as you know, the title is vested in the trustee as on behalf of the trust. So it's not vested in the individual to be dead or alive. So that individual can die, but the trust still has ownership of the property. So that doesn't change.
So I've had a question before, Josh, where the client bought their home before they had the trust. Mm-hmm. So title insurance is just vested in the name of Tom and Mary Jones. Mm-hmm. Then they get their trust. They put the title of the property in the trust, but they don't go back and change the policy. It's still just Tom and Mary Jones. It doesn't say the Jones family trust,
That's a good
technically.
one. Yeah.
And I believe the policy still extends as long as it's a grantor trust functioning under their social security numbers, and they're the sole beneficiaries and sole trustors. I believe that title coverage probably extends, doesn't it, to the trust?
Title should, generally speaking, extend to that. You really do want to reach out to your title company, get the endorsement that endorses the policy into the new vesting entity. But I'm trying to think of a scenario if they put it back into a trust, will they not have coverage for it? It's not a transfer to a new person. It's just a different version of vesting ownership.
I think there's actually some legislation on that. I know there is with respect to mortgages. Technically, a due on sale clause. You transfer your property to somebody else, the mortgage is due, but that doesn't apply if you're transferring it to yourself in a trust. Well, maybe there might be some legislation on that. Another thing I've always wanted to know, Josh, is who actually does the insuring on a title insurance policy. For example, Orange County Title. Most of us are used to buying car insurance and life insurance, so we know who Geico is, we know MetLife, we know Prudential. Where do you go? Where does your escrow company go to actually pull the insurance from? Who's the real insurer?
So Orange Coast Title Company is an issuing agent, and Orange Coast Title Company is an agent for a lot of the big title companies. So Fidelity, First American, Stewart. So it's and there's another one that's related. It's called Real Advantage Title Insurance Company. So they'll reach out to these the big issuing agents, the big issuers of title policies, and the escrow company or the title unit of Orange Coast Title Company, whatever you're dealing with. They'll write the paper that has the insurer's name on it, which is one of the big insurers. So they're the agent. So but the principal is going to issue the policy.
Yeah. Good to know.
Yeah.
Well, that's really, really, really helpful, Josh. We're so glad you could come visit us today. And we've actually worked with your title company. They did a great job.
I'm glad to hear it.
Look forward to doing more business together in the future.
That'd be a pleasure, and I hope we do business again in the future, and hope we do as good of a job as we did before.
Thank you again.
Sure, you're welcome. Thanks for having me.
And I think we got a little something for you, Josh, for taking the time to be here. Compliments of Modern Trust, where you can get your living trust, will, power of attorney, healthcare directive, full estate plan online. Something that's a benefit, and we're doing a podcast to get more information about protecting yourself and your assets. So we appreciate that. Compliments of Modern Trust.
Well, thank you so much. Appreciate it. It was very nice.
Okay. Bye, everybody.
Bye.